I took my seat behind the bench in Providence Municipal Court the way I always do, quietly, deliberately, because the moment a judge walks in, the room takes its cue. The bench was worn smooth from decades of hands and decisions, and I've learned that on a busy calendar day, the courtroom has its own kind of rhythm, paper shuffling, shoes soft against marble, a nervous pen clicking in the gallery. Most people try to act calm, but the room tells the truth anyway. The clerk called the next matter, and I looked down at the file in front of me. Traffic counts, a misdemeanor, a timeline, a few pages of reports, and then the name, Marianne Whitlock. I've been on the bench long enough to recognize what happens when a name like that enters the air. People in the room react before anyone speaks. It's subtle, but it's there. A shift in posture, a slight tightening, the quiet question behind their eyes. Will the rules be the same today? The rules are always the same in my courtroom. That's the point of having rules. I looked up. Good morning, I said. We're here on the matter of the city versus Marianne Whitlock. My bailiff, Officer Dempsey, stood to the side with that steady readiness good officers have, shoulders square, eyes moving, hands relaxed but prepared. A courtroom doesn't need muscle, it needs control. Dempsey understood that. Marianne came in just a little late, 2 minutes, not enough to apologize, just enough to announce herself without words. She wore a coat that belonged at a fundraiser, hair perfect, chin lifted, sunglasses indoors until she reached counsel table, then off, like she was stepping into a role. And behind her, 3 attorneys, not 1. Not 2, 3. They approached the defense table with the confidence of people who weren't there to learn what happened. They were there to manage what happened. On the other side of the aisle stood the prosecutor, Assistant City Prosecutor Nadia Klein. Ms. Klein has the look of someone who has spent years dealing with the difference between noise and evidence. Clothing doesn't impress prosecutors. Paperwork doesn't impress them either. Proof does. I glanced to the other end of counsel table, and I saw what I always look for in cases like this. The people who didn't choose to be here. A young mother holding a little boy's hand. The boy was small, 6 years old maybe. He wore a puffy jacket, too big in the sleeves, like it had been passed down, shoes slipping slightly off his heels. The mother kept smoothing his hair with her free hand, over and over, not vanity, comfort. Her name on the file was Maya Rios, 29, single mother. Beside her sat an older man with his right arm in a sling. 70, according to the report, Leonard Quinn, retired school crossing guard. He sat carefully, like moving too fast would cost him. A man used to being helpful, not used to being watched. I took that in because details matter. People don't come to court as facts, they come as lives. And when a case is about entitlement versus accountability, the smallest movements tell you what words try to hide. I looked back to counsel. The appearances for the record. A man rose first. Your Honor, Michael Harlan for Ms. Whitlock. A second attorney nodded. Evelyn Rusk, co-counsel. A third, younger attorney spoke. Daniel Cho, for the record, Your Honor. 3 lawyers, 1 defendant. I looked at the prosecutor. Ms. Klein. Good morning, Your Honor, she said. Let's go through the charges, I said. What are we here on? Ms. Klein opened her folder. Your Honor, the defendant is charged with reckless operation, failure to yield to pedestrians in a crosswalk, leaving the scene of an accident involving personal injury and disorderly conduct. Before she could finish, the defendant let out a long exhale, loud enough for the front row to hear, like the words were insulting her personally. It wasn't an accident, Marianne said, without being recognized. It was a misunderstanding. I didn't raise my voice. I didn't need to. I let the silence hold her words for a beat, long enough for her to feel the weight of speaking out of turn. Ms. Whitlock, I said, you will not speak out of turn in my courtroom. Your counsel will speak for you unless I ask you a direct question. She blinked quickly, like the concept of being told no in public was unfamiliar. Mr. Harlan started to step in. Your Honor, if I may. 1 at a time, I said. Mr. Harlan, you'll have your turn. Marianne leaned toward him and whispered. I couldn't hear the words, but I saw the posture. The whisper wasn't concern, it was instruction. People who are used to controlling rooms try to control this room. That is exactly why procedure exists. I turned back to the file. How does the defendant plead? Not guilty, Your Honor, Mr. Harlan said. Very well, I said. Ms. Klein, give me your summary. The prosecutor spoke in a measured rhythm. On October 14th, at approximately 6:42 p.m., the defendant was operating a silver SUV exiting the parking lot of Bellamy's Bistro on Kestrel Avenue. 2 pedestrians, Mr. Leonard Quinn and Ms. Maya Rios, were in the marked crosswalk. The defendant accelerated, struck Mr. Quinn, causing injury, continued forward, and left the scene. Miss Rios attempted to stop the vehicle and was verbally berated. Police were called, and the defendant was later identified via security footage and vehicle registration. Marianne gave a short laugh, small, sharp, dismissive. That laugh didn't just land, it cut, because it wasn't a laugh at a joke. It was a laugh at the idea that consequences belonged in her life. I looked directly at her. "Ms. Whitlock," I said, "this is court. The allegations involve a 70-year-old man with an injury and a mother with a child. If you have a reaction, you keep it to yourself." She held my gaze with something that wasn't remorse. It was irritation, like the world wasn't cooperating. "Proceed," I said to the prosecutor. Ms. Klein moved to evidence. "Your Honor, the city intends to introduce security video, body-worn camera footage, testimony from Officer Joan Appel, and testimony from Mr. Quinn and Miss Rios." "All right," I said. "Let's see it." The courtroom monitor flickered as the technician adjusted cables. It's always interesting how a room responds to screens. People argue with words. They argue less with pictures. The first video played, exterior footage from the restaurant, high angle. You could see the parking lot exit, the sidewalk, the crosswalk stripes, faded but visible. Dusk lighting, that in-between hour when everything looks softer than it is. Maya entered the crosswalk holding her child's hand. Leonard followed a half-step behind, positioned slightly toward the child like a habit he couldn't turn off. That detail mattered. It told me he wasn't distracted, he wasn't careless, he was protective. The silver SUV rolled to the exit and stopped briefly, a pause that looked like compliance. Then the vehicle surged, not a slow roll. A surge. Impatient movement you could feel even without sound. Maya yanked her son back. The boy stumbled. Leonard turned toward them instinctively, and then the corner of the SUV struck Leonard. Leonard went down. Not theatrically, not exaggerated, the way a body goes down when it has no choice. The SUV stopped for half a second, then it moved again. It moved around him, around a man on the ground, and pulled out onto the street. In the gallery, someone inhaled sharply. Someone whispered a word they thought the court couldn't hear. Officer Dempsey shifted his weight slightly, the way an officer does when his instincts wish he could step into the video and stop it. I didn't say anything. I watched Marianne. She leaned back in her chair and crossed her legs slowly like she was bored. And I remember thinking, that's not just a driving issue. That's a mindset, a belief that people in your way are obstacles. Ms. Klein offered the footage as Exhibit 1. The defense objected on foundation. The restaurant manager authenticated the system and the extraction. Exhibit 1 was admitted. Ms. Klein called Officer Joan Appel. Officer Appel took the oath and sat in the witness chair, uniform crisp, tone careful. The type of officer who understands every word can be replayed. He described arriving to find Leonard on the sidewalk in visible pain, Maya shaken, the child crying. He described the crosswalk, the scene, the direction witnesses pointed, vehicle fled. "Did you later make contact with the defendant?" Ms. Klein asked. "Yes," Officer Appel said. "Approximately an hour later, we made contact at the defendant's residence." "And what occurred?" He paused, not uncertain, choosing words. "She was uncooperative," he said. "She declined to provide a statement. She told me I was mistaken about her vehicle. And she said, quote, 'Do you know who my husband is?'" Marianne's head snapped up. "That's not what I said," she blurted. The courtroom went still. Even the pen clicking stopped. I let the silence sit for a moment because sometimes silence does the work that volume can't. "Ms. Whitlock," I said, calm, "that is your second interruption. You will not speak out of turn." Mr. Harlan started. "Your Honor, she's reacting." "No," I said, "she's testing." Marianne's cheeks flushed. "I'm allowed to defend myself." "You're allowed to speak when it is your turn," I said. "You are not allowed to run over procedure because testimony is uncomfortable." Officer Appel continued. The defendant called it a waste of time, told him to deal with her attorney, and asked nothing about the injured party. Mr. Harlan cross-examined, trying to reduce the testimony to demeanor is subjective. Officer Appel didn't take the bait. "I recorded the encounter on my body-worn camera," he said. "That changed the air. People who rely on intimidation don't like recordings." Ms. Klein called Maya Rios. Maya stepped into the witness stand with the posture of someone who had to be strong for a child. She took the oath. Her hands gripped the chair. "It was my son's birthday," she said. "We were leaving dinner. Mr. Quinn held the door for us. Leonard kept his eyes down. like he didn't want attention. The car stopped, Maya said. So we went, and then it sped up, like we weren't there. Her voice trembled on disbelief. I pulled my son back, she said. Mr. Quinn turned toward us, and the car hit him. She paused, held herself together. After he fell, she continued, I went to the driver's window. I was yelling, stop, you hit him. And she looked at me like I was trash. Then she said the words that tightened the whole room. She said, maybe if you spent less time having kids you can't afford, you'd teach them not to run into traffic. That kind of cruelty doesn't need a microphone. It spreads on its own. My son heard it, Maya said. He asked me if we were poor. He asked me if it was our fault, she finished simply. Then she drove away. Defense objected to the statements. Ms. Klein responded, party opponent, I overruled. The statements were admissible. Maya also testified that someone contacted her afterward and offered to make this easy, to send a check. I didn't want a check, Maya said. I wanted her to admit what she did. I wanted my son to know you don't hurt someone and pay your way out. Then Leonard Quinn testified. He stood slowly, oath taken, sat with his sling visible. Physical proof this wasn't hypothetical. I was crossing, he said quietly. Like I've crossed 1,000 times. I saw the boy. I saw the mother. He paused. I felt the hit. Not a crash, a shove, like the world decided I was in the way. His injuries were real. Loss of mobility, loss of driving, loss of helping his family, loss of volunteering. He also testified someone came to his apartment offering money. I told him, Leonard said, looking at me as if checking he could speak plainly. I wasn't for sale. Mr. Harlan tried to cross-examine Leonard on age, balance, perception. Leonard answered steadily. I would agree I'm older. I would not agree that makes it okay to hit me. Then Leonard said something that stayed in the room. Sir, I spent 15 years holding up a stop sign for children. I know what it looks like when a driver is waiting, and I know what it looks like when a driver decides they're more important. The defense's tone shifted after that because sincerity is hard to bully. Mr. Harlan presented the defense narrative. Stress, panic, didn't see them, didn't know there was an accident, frightened by Maya's approach. He emphasized the offer to pay as good faith and asked that it be treated like a civil matter. I listened. I always listen. But I also know tactics when I hear them. Offering money after the fact does not erase criminal responsibility, I said. And good faith is not measured by a check. It's measured by conduct. Then Mr. Harlan tried a move I don't allow. Your Honor, he said, my client is the spouse of State Senator Grant Whitlock. Stop, I said. One word. No anger. Just a boundary. Do not attempt to introduce political status as a shield. It is irrelevant to guilt or innocence. Marianne's face tightened, and then she reached for what she thought was power. She lifted her phone, screen bright, and began tapping in open court. Ms. Whitlock, I said, put the phone down. She didn't. I need to make a call, she said. No, I said. You can't tell me I can't call my husband. I can tell you what happens in my courtroom, I replied. No phones, no interruptions, no treating this court like customer service. She pressed the screen anyway. I heard the faint sound of a call starting. I turned slightly. Bailiff, I said. Approach. Officer Dempsey stepped forward. Take the phone, I said. Marianne clutched it tighter. This is ridiculous. Ms. Whitlock, I said. You've been warned. This is contemptuous behavior. Hand the phone to the bailiff. The room held its breath for a moment. Maya's little boy even stopped moving, sensing the tension. Then Marianne thrust the phone forward into the bailiff's hand, hard, like she wanted it to look like a theft instead of a consequence. Thank you, I said. Marianne stood. Do you know who you're doing this to? I know exactly who I'm doing this to, I said. A defendant, in a courtroom, under rules that apply to everyone. Then I made a decision that was both firm and fair. You want to call your husband? I asked. Yes, she said, like the answer should change the room. Fine, I said, but you'll do it the right way. I ordered one supervised call, on speaker, through the court line. No coaching, no theatrics, and I stated clearly, any attempt to interfere would be documented and addressed. The line rang. A man answered. This is Senator Whitlock. Marianne's posture straightened, as if the courtroom should reorganize around that voice. Grant, she began loudly, I'm in court, and this judge is... I cut in immediately. Senator, this is Providence Municipal Court. I am the presiding judge. This call is on speaker in open court. Your spouse is a defendant. The purpose of this call is not to influence the court. Do you understand? A pause. Yes, he said. I understand. Marianne looked at the phone as if it failed her. She tried again. Grant, they're making this into something it's not. Marianne, the senator said, and his tone sharpened. Stop talking. The gallery leaned in without realizing it. I'm not calling to fix this, he continued. I'm not calling to pressure anyone. If you're in court, you listen, you follow the judge's instructions, and you take responsibility for whatever you did. Then he addressed me. Your Honor, I apologize for the interruption. I will not interfere with your proceedings. Thank you, Senator, I said. And if restitution is required, he added, it will be handled properly. But I'm not calling to negotiate. I'm calling to tell my spouse to respect the court. The call ended. The silence afterward told the room exactly what happened. The lifeline didn't rescue her. It corrected her. Ms. Klein introduced the body cam audio. It played in open court. The defendant's voice came through, sharp and dismissive. This is absurd. Video can be wrong. Then send them a bill. And again the line, do you know who my husband is? The city also introduced the messages and note offering money and warning of attention you don't want if the victims insisted on court. That crossed the line. Restitution is a lawful process. Pressure and threats are not. I asked Marianne directly whether she authorized the contacts. She tried to dodge. I didn't write them. That wasn't my question, I said. I told my assistant to handle it. She admitted. I nodded once. All right. Then I took the record as a whole. The video, the testimony, the audio, the post-incident conduct. Ms. Whitlock, I said, stand. She stood. I'm going to make findings based on what I've seen and heard, I said. I summarized the video. Pedestrians in crosswalk first, vehicle stopped, then accelerated, contact with Mr. Quinn, vehicle stopped, then drove around him and left. I summarized the body cam. Her statements showed awareness and a dismissive attitude. Her claim that she didn't know there was an accident wasn't credible. The testimony of Ms. Rios and Mr. Quinn was credible, I said, because it was consistent, specific, and corroborated by video. Then I addressed what mattered beyond the traffic moment. Your conduct afterward, offering money and applying pressure, demonstrates a belief that rules are negotiable if you have influence. I said, that belief is the problem. She tried to twist it. So you're punishing me because I'm married to a senator? No, I said calmly. I'm holding you accountable because you drove into a crosswalk, injured a man, left the scene, and then tried to use money and influence to avoid responsibility. I entered findings of guilt on reckless operation, failure to yield, leaving the scene with injury, and disorderly conduct. She said, this is going to ruin my family. I answered, I understand what your choices did to other families first. Then I moved to sentencing. In municipal court, we don't have endless power. We have specific tools. Fines, restitution, probation, suspension, programs, and sometimes custody within statutory limits. I use what the law allows, and I use it with intention. I imposed fines, ordered restitution for Mr. Quinn's medical expenses and documented out-of-pocket costs, and ordered restitution for Ms. Rios's documented expenses connected to the incident and court appearances. I suspended her license for 90 days. She started to interrupt. 90? You will not interrupt me, I said, and she stopped. I placed her on supervised probation for 12 months, anger management and accountability counseling, a certified driver safety course focused on pedestrian right-of-way, and a strict no-contact order. No direct or indirect contact with Ms. Rios or Mr. Quinn, no assistance, no intermediaries, no messages. Then I ordered community service, 120 hours with the Senior Mobility Program, transporting seniors to medical appointments and grocery access. She looked stunned by that. You will show up on time, I told her. You will listen, you will wait, and if a senior is slow, you will not sigh. You will not roll your eyes. You will not act like they're in your way, because that is what brought you here. Finally, I ordered a real apology letter, written by her, not counsel, read aloud in court at a compliance review. If she didn't want that condition, she could decline probation and accept incarceration within statutory limits. Probation is an opportunity, not a gift. She chose probation. Before concluding, I asked Leonard if he wanted to say anything. I don't want revenge, he said, but I want her to understand. When you're driving and you see people walking, you're not seeing obstacles, you're seeing lives. Maya spoke too. I don't want my son growing up thinking money and titles let people hurt you and disappear you with a check, she said. I want him to know the rules are real. I looked at Marianne. You heard them. Then I said the boundary I always come back to. This court is not impressed by who you know. This court is impressed by who you are when nobody is giving you special treatment. I set a compliance review for 60 days. The bailiff returned the phone after court concluded, because consequences end when court ends, not before. 60 days later, Marianne came back for review. This time, no sunglasses, no dramatic coat, 2 lawyers, not 3. The performance was quieter. Life has a way of doing that once consequences become real. Maya returned because she had to for the apology. Leonard returned too, sling gone, but shoulder still stiff. Probation reported, 42 service hours completed, 5 counseling sessions attended, fines paid to date, restitution started, no violations. 1 early note, attitude issues, impatience with delays, later reports, improvement. I asked Marianne if it was accurate. Yes, she said. I asked her to explain the note. She hesitated, then spoke without trying to win. I sighed, she admitted. An older woman moved slowly. She needed help getting into the van. I was frustrated. And what happened? I asked. The supervisor pulled me aside, she said. He said, you don't sigh at people who are trying their best. If you can't do this, you leave. I wanted to leave. And? I said. I didn't, she answered quietly. I apologized to the woman. Then the apology letter. It was handwritten. The ink looked uneven, like she rewrote parts. She read it aloud, admitting she drove into the crosswalk, hurt Leonard, scared Maya and her son, and left when she should have stayed and called for help. She admitted the cruel words. She admitted trying to fix it with money. She admitted she tried to buy her way out of truth and dignity. When she finished, Leonard gave a small nod. No dramatic forgiveness, just acknowledgement. Maya didn't offer a hug or a speech. She said, I appreciate you said it out loud. My son needed to hear it. I don't want to be contacted again. I just want to move on. Marianne nodded. I understand. That's how real resolution often looks. Not a miracle, just a boundary respected. I told Marianne the review was not the end. You've done some of the work, I said. Keep doing it. Don't do it for cameras. Do it because you learned something you didn't know you needed. And I told her the truth she needed to carry. The moment you picked up a phone in my courtroom and tried to call your way out of consequences, that wasn't strength, I said. That was weakness. Real strength is standing in what you did and changing your behavior without anyone forcing you. I set the next review. Supervision continued. Later, a final compliance report came across my desk. She completed all service hours, continued counseling, no violations, restitution paid on schedule. The supervisor wrote something small. She learned to wait. She learned to listen. Those aren't glamorous lessons. They don't make headlines. But they are the difference between someone who keeps hurting people and someone who stops. I don't pretend courts can guarantee redemption. We can't. We can enforce boundaries and offer a pathway. The person has to choose what they become after the courtroom stops watching. But I do know what that day taught everyone who sat in that room. Maya learned the rules are real. Leonard learned he wasn't invisible. The gallery learned that influence has limits when a court holds the line. And Marianne learned what a lot of people learned too late. Restitution can be paid, but innocence can't be bought. I closed the file the same way I close every file, without celebration, without anger. Just the quiet understanding that the law only means something if it belongs to everyone. Then I called the next case.